consumers for the same month of the preceding calendar year, rounded to the next lowest multiple, $10. C, exception. The fee described in this section shall not apply to any alien who was ordered removed in absentia if such order was rescinded pursuant to Section 240B5C, US 8 U.S.C. 1229A B5C. D, disposition of removal in absentia fees. During each fiscal year, 1, 50% of the fees collected pursuant to this section A shall be credited to U.S. Immigration and Customs Enforcement. B, shall be deposited into the Detention and Removal Office fee account. And C, may be retained and expended by U.S. Immigration and Customs Enforcement without further appropriation. And 2, any amounts collected pursuant to this section are not credited to U.S. Immigration and Customs Enforcement pursuant to paragraph 1 shall be deposited into the general fund of the Treasury. E, no fee waiver.
People come to us and their teeth are so bad that they all need to be extracted. They all need to be taken out and they need to get brand new teeth. But traditionally, the old way of doing this, it usually can take somewhere up to 10
Homeland Security shall require the payment of a fee equal to the amount specified in subsection B by any inadmissible alien at the time of such alien is apprehended between ports of entry. B, amount specified. 1, initial amount. For fiscal year 2025, the amount specified in the section shall be the greater of A, $5,000, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in the section shall be equal to the sum of A, the amount of the fee required under the subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded up to the next lowest multiple of $10. C, disposition of inadmissible alien apprehension fees. During each fiscal year, 1, 50% of the fees collected pursuant to this section A shall be credited to U.S. Immigration and Customs Enforcement. B, shall be deposited into the Detention and Removal Office fee account. And C, may be retained and expended by U.S. Immigration and Customs Enforcement without further appropriation. And 2, any amounts collected pursuant to this section are not credited to U.S. Immigration and Customs Enforcement pursuant to paragraph 1 shall be deposited into the general fund of the Treasury. D, disposition of inadmissible alien apprehension fees. All of the fees collected pursuant to the section shall be deposited into the general fund of the Treasury. Section 100018, amendment to authority to apply for asylum. Section 208D3, 8 U.S.C. 1158D3 is amended. 1, in the first sentence by striking may and inserting shall. 2, by striking such fees shall not exceed, and all that follows, and inserting the following. Nothing in this paragraph may be construed to limit the authority of the Attorney General to set additional adjudication and naturalization fees in accordance with Section 286M. Part 2, Immigration and Law Enforcement Funding, Section 100051, appropriation for the Department of Homeland Security. In addition to the amounts otherwise available, there is appropriated to the Secretary of Homeland Security for fiscal year 2025 out of any money in the Treasury not or otherwise appropriated.
Men doing at least 150 grand a year. If you're completely out of shape, let's drop the ego and get real for a moment. If you haven't been ripped in 10 years, understand that you might think you know what to do, but it's clearly not working. If you could have done it on your own, you would have had. Listen, no matter where your physique is at right now,
2029 for the following purposes. 1, immigration and enforcement activities, hiring and training of additional U.S. Customs and Border Protection Agency and the necessary support staff to carry out immigration enforcement activities. 2, departures and removal, funding for transportation costs and related costs associated with the departure of or removal of aliens. 3, personal assignments, funding for the assignment of Department of Homeland Security employees and state officers to carry out immigration enforcement activities pursuant to sections 103A and 287G of the Immigration and Nationality Act, 8 U.S.C. 1103A and 1357G. 4, background checks, hiring additional staff and investing the necessary resource to enhance screening and vetting of all aliens seeking entry into the United States, consistent with Section 212 of such Act, 8 U.S.C. 1182, or intending to remain in the United States consistent with Section 237 of such Act, 8 U.S.C. 1227. 5, protecting alien children from exploitation. In instances of alien and alien children entering the United States without a valid visa, funding is provided for the purposes of A, collecting fingerprints in accordance with Section 262 of the Immigration and Nationality Act, 8 U.S.C. 1302, and subsections A, 3, and B of Section 235 of such Act, 8 U.S.C. 1225, and B, collecting DNA in accordance with Sections 235D and 287B of the Immigration and Nationality Act, 8 U.S.C. 1225D and 1357B. 6, transporting and return of aliens from contiguous territory. Transporting and facilitating the return pursuant to Section 235B2C of the Immigration and Nationality Act, 8 U.S.C. 1225B2C of aliens arriving from contiguous territory. 7, state and local participation. Funding for state and local participation in Homeland Security efforts for the purposes of A, ending the presence of criminal gangs and criminal organizations throughout the United States. B, addressing crime and public safety threats. C, combating human smuggling and trafficking networks throughout the United States. D, supporting immigration enforcement activities, and E, providing reimbursement for state and local participation in such efforts. 8, removal of specified unaccompanied alien children. A, in general, funding removal operations for specified unaccompanied alien children. B, use of funds. Amounts made available under this paragraph shall only be used for permitting a specified unaccompanied alien child to withdraw the application for admission of the child pursuant to Section 235A4 of the Immigration and Nationality Act, 8 U.S.C. 1225A4. C, definitions. In this paragraph, 1, specified unaccompanied alien child. The term specified unaccompanied alien child means unaccompanied alien child is defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, who the Secretary of Homeland Security determines on a case-by-case basis. 1, has been found by an immigration officer at a land border or port of entry of the United States and is inadmissible under the Immigration and Nationality Act, 8 U.S.C. 1101 et sec. 2, has not been a victim of severe forms of trafficking in persons, and there is no credible evidence that such child is at risk of being trafficked upon return of the child to the child's country of nationality or country of last habitual residence. And 3, does not have a fear of returning to the child's country of nationality or country of last habitual residence owing to a credible fear of persecution. 2, severe forms of trafficking in persons. The term severe forms and trafficking in persons has the meaning given such term in Section 103 of the Trafficking Victims Protection Act of 2000, 22 U.S.C. 7102. 9, expedited removal of criminal aliens. Funding for the expedited removal of criminal aliens in accordance with the provisions of Section 235B1 of the Immigration and Nationality Act, 8 U.S.C. 1225B1. 10, removal of certain criminal aliens without further hearings. Funding for the removal of certain criminal aliens without further hearings in accordance with the provisions of Section 235C of the Immigration and Nationality Act, 8 U.S.C. 1225C. 11, criminal and gang checks for unaccompanied alien children. Funding for criminal and gang checks of unaccompanied alien children is defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, who are 12 years of age and older, including the examination of such unaccompanied alien children for gang-related tattoos and other gang-related markings. 12, information technology investments to support immigration purposes, including improvements to fee and revenue collections. Section 100052, appropriation for U.S. Immigration and Customs Enforcement. In addition to amounts otherwise available, there is appropriated to the Secretary of Homeland Security for U.S. Immigration and Customs Enforcement for fiscal year 2025 out of any money in the Treasury not otherwise appropriated.
Have you ever heard of an economy being taxed into prosperity?
Enforcement personnel, including officers, agents, investigators, and support staff to carry out immigration enforcement activities, and prioritizing the streamlining and hiring of retired U.S. Immigration and Customs Enforcement personnel. 2, performance, retention, and signing bonuses. A, in general, providing performance, retention, and signing bonuses for qualified U.S. Immigration and Customs Enforcement personnel in accordance with the subsection. B, performance bonuses. The Director of U.S. Immigration and Customs Enforcement, at the Director's discretion, may provide performance bonuses to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who demonstrates exemplary service. C, retention bonuses. The Director of U.S. Immigration and Customs Enforcement may provide retention bonuses to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who commits to 2 years of additional service with U.S. Immigration and Customs Enforcement to carry out immigration enforcement activities. D, signing bonuses. The Director of U.S. Immigration and Customs Enforcement may provide a signing bonus to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who, 1, is hired on or after the date of the enactment of this act, and 2, who commits to 5 years of service with U.S. Immigration and Customs Enforcement to carry out immigration enforcement activities. E, service agreement. In providing a retention or signing bonus under this paragraph, the Director of U.S. Immigration and Customs Enforcement shall provide each qualifying individual with a written service agreement that includes 1, the commencement and termination dates of the required service period or provisions of the determination of such dates, 2, the amount of the bonus, and 3, any other term or condition under which the bonus is payable subject to the requirements of this paragraph, including 1, the condition under which the agreements may be terminated before the agreed upon service period has been completed, and 2, the effect of the termination described in the subclause 1. 3, recruitment, hiring, and onboarding. Facilitating the recruitment, hiring, and onboarding of additional U.S. Immigration and Customs Enforcement personnel to carry out immigration enforcement activities, including by A, investing in information technology recruitment and marketing, and B, hiring staff necessary to carry out information technology recruitment and marketing activities. 4, transportation, funding for transportation costs and related costs associated with alien departure or removal operations. 5, information technology, funding for information technology investments to support enforcement and removal operations, including improvements to fee collections. 6, facility upgrades, funding for facility upgrades to support enforcement and removal operations. 7, fleet modernization, funding for fleet modernization to support enforcement and removal operations. 8, family unity, promoting family unity by A, maintaining the care and custody during the period in which a charge described in Clause 1 is pending in accordance with the applicable laws of an alien who, 1, is charged only with a misdemeanor offense under Section 275A of the Immigration and Nationality Act, 8 U.S.C. 1325A, and 2, entered the United States with the alien's child who has not attained 18 years of age, and B, detaining such an alien with the alien's child. 9, 287G agreements, expanding, facilitating, and implementing agreements under Section 287G of the Immigration and Nationality Act, 8 U.S.C. 1357G. 10, Victims of Immigration Crime Engagement Office, hiring and training additional staff to carry out the mission of the Victims of Immigration Crime Engagement Office and for providing non-financial assistance to the victims of crime perpetrated by aliens who are present in the United States without authorization. 11, Office of the Principal Legal Advisor, hiring additional attorneys and the necessary support staff within the Office of the Principal Legal Advisor to represent the Department of Homeland Security and Immigration Enforcement and Removal Proceedings. Section 100053, Appropriation for Federal Law Enforcement Training Centers. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Secretary of Homeland Security for the Federal Law Enforcement Training Centers for fiscal year 2025 out of any money in the Treasury not otherwise appropriate, $750 million to remain available until September 30th, 2029 for the purposes described in subsection B and C. B, training, not less than $285 million of the amounts available under subsection A shall be for supporting the training of newly hired federal law enforcement personnel employed by the Department of Homeland Security and state and local law enforcement agencies operating in support of the Department of Homeland Security. C, facilities, not more than $465 million of the amount available under subsection A shall be for procurement, construction, and maintenance of improvements to training equipment for and related expenses of facilities to the federal law enforcement training centers. Section 100054, appropriation for the Department of Justice. In addition to amounts otherwise available, there is appropriated to the Attorney General for the Department of Justice for fiscal year 2025 out of any money in the Treasury not otherwise appropriate $3,330 million to remain available through September 30th, 2029 for the following purposes. 1, Executive Office for Immigration Review. A, in general, hiring immigration judges and necessary support staff for the Executive Office for Immigration Review to address the backlog of petitions, cases, and removals. B, staffing levels. Effective November 1, 2028, the Executive Office for Immigration Review shall be comprised of not more than 800 immigration judges along with the necessary support staff. 2, combating drug trafficking. Funding efforts to combat drug trafficking, including trafficking of fentanyl and its precursor chemicals and illegal drug use. 3, prosecution of immigration matters. Funding efforts to investigate and prosecute immigration matters, gang-related crimes involving aliens, children trafficking, and smuggling involving aliens within the United States, unlawful voting by aliens, violations of the Alien Registration Act, 1940, 54 Stat, Chapter 439, and violation of or fraud relating to Title IV of the Personal Responsibility and Work Opportunity Act of 1996, Public Law 104-193, 110 Stat 2277, including hiring additional Department of Justice personnel to investigate and prosecute such matters. 4, non-party or other injunctive relief, hiring additional attorneys and necessary support staff for the purpose of continuing implementation of assignments by the Attorney General pursuant to sections 516, 517, and 518 of Title 28 United States Code to conduct litigation and tend to the interests of the United States in suits pending in a court of the United States or in a court of the state in suits seeking non-party or other injunctive reliefs against the federal government.
Utility companies in New England now charge you around 50% just to deliver your electricity to your home, but you can instantly eliminate within the next 90 seconds.
In general, increasing funds for the Edward Byrne Memorial Justice Assistant Grant Program and the Office of Community-Oriented Policing for initiatives associated with investigating and prosecuting violent crime. 2, criminal enforcement initiatives. And 3, immigration enforcement and removal efforts. B, limitations. No funds made available under the subsection shall be made available to community violence intervention and prevention initiative programs. C, eligibility. To be eligible to receive funds made available under the subsection, a state or local government shall be in full compliance as determined by the Attorney General with Section 642 of the Legal Immigration Reform and Immigrant Responsibility Act of 1996, 8 U.S.C. 1373. 6, fiscally responsible lawsuit settlements, hiring additional attorneys and necessary support staff for the purposes of maximizing lawsuit settlements that require the payment of fines and penalties to the Treasury of the United States in lieu of providing for the payment to any person or entity other than the United States, other than a payment that provides restitution or otherwise directly remedies actual harm directly in proximity caused by the party making the payment or constitutes payment for services rendered in connection with the case. 7, compensation for incarceration of criminal aliens. A, in general, providing compensation to a state or political subdivision of a state for the incarceration of criminal aliens. B, use of funds. The amounts made available under subparagraph A shall only be used to compensate a state or local subdivision of a state as appropriate with respect to the incarceration of an alien who, 1, has been convicted of a felony or 2 or more misdemeanors, and 2, 1, entered the United States without inspection or at any time or place other than designated by the Secretary of Homeland Security. 2, was the subject of removal proceedings at the time the alien was taken into custody by the state or a political subdivision of the state, or 3, was admitted as a non-immigrant and at the time the alien was taken into custody by the state or a political subdivision of the state had failed to maintain the non-immigrant status in which the alien was admitted or to which it was changed or to comply with the conditions of any such status. C, limitation. Amounts made available under the subsection shall be distributed to more than one state. The amounts made available under subparagraph A may not be used to compensate any state or political subdivision of a state if the state or political subdivision of the state prohibits or in any way restricts a federal, state, or local government entity, official, or other personnel from doing any of the following. 1, complying with the immigration laws as defined in Section 101A-17 of the Immigration Nationality Act, 8 U.S.C. 1101A-17. 2, assisting or cooperating with federal law enforcement entities, officials, or other personnel regarding the enforcement of the immigration laws. 3, undertaking any of the following law enforcement activities as such activities relate to information regarding the citizenship or immigration status, lawful or unlawful, the admissibility or deportability, and the custody status of any individual. 1, making inquiries to any individual to obtain such information regarding such individual or any other individuals. 2, notifying the federal government regarding the presence of individuals who are encountered by law enforcement officials or other personnel of the state or political subdivision of a state. 3, complying with requests with such information from federal law enforcement entities, officials, or other personnel. Section 100055, Bridging Immigration-Related Deficits Experience Nationwide Reimbursement Fund. A, establishment. There is established within the Department of Justice a fund to be known as the Bridging Immigration-Related Deficit Experience Nationwide Biden Reimbursement Fund, referred to in this section as the fund. B, use of funds. The Attorney General shall use amounts appropriated or otherwise made available for the funds for grants to eligible states, state agencies, and units of local government pursuant to their existing statutory authorities for any of the following purposes. 1, locating and apprehending aliens who have committed a crime under federal, state, or local law in addition to being unlawfully present in the United States. 2, collection and analysis of law enforcement and investigation information within the United States to counter gang or other criminal activity. 3, investigating and prosecuting A, crimes committed by aliens within the United States, and B, drug and human trafficking crimes committed within the United States. 4, court operations related to the prosecution of A, crimes committed by aliens, and B, drug and human trafficking crimes. 5, temporary criminal detention of aliens. 6, transporting aliens described in paragraph 1 within the United States to locations related to the apprehension, detention, and prosecution of such aliens. 7, vehicle maintenance, logistics, transportation, and other support provided to law enforcement agencies by state agencies to enhance the ability to locate and apprehend aliens who have committed crimes under federal, state, or local law in addition to being unlawfully present in the United States. C, appropriation. In addition to amounts otherwise available for the purposes described in subsection B, there is appropriated to the Attorney General for fiscal year out of any money in the Treasury not otherwise appropriated, not to exceed
Should these glasses be illegal in the U.S.? Don't risk straining your eyes or wasting money on outdated prescription glasses. These incredible new glasses can instantly adjust to your eyesight in real time. Forget fixed lenses.
Until September, $3.5 billion to be remain available until September 30th, 2028 for the fund of qualified and documented expenses that achieve such purpose. D, grant eligibility for completed, ongoing, or new activities. The Attorney General may provide grants under this section to state agencies and units of local government for expenditures made by state agencies or local government for completed, ongoing, or new activities determined to be eligible for such grant funding that occurred on or after January 20th, 2021. Amounts made available under this section shall be distributed to more than one state. Section 100056, appropriation for the Bureau of Prisons. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of Bureau of Prisons for fiscal year 2025 out of any money in the Treasury not otherwise appropriated. $5 billion to remain available through September 30th, 2029 for the purposes described in subsections B and C. Salaries and benefits, not less than $3 billion of the amount made available under subsection A shall be for hiring and training of new employees, including correctional officers, medical professionals, and facilities and maintenance employees, the necessary support staff, and for additional funding for salaries and benefits for the current workforce of the Bureau of Prisons. C, facilities, not more than $2 billion of the amount made available under subsection A shall be for addressing maintenance and repairs to facilitate, maintained, or operated by the Bureau. Repairs to facilities maintained or operated by the Bureau of Prisons. Section 10057. Appropriation for the United States Secret Service. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of the United States Secret Service, referred to in the section as the Director, for fiscal year 2025 out of any money in the Treasury not otherwise appropriate. $1.170 billion to remain available through September 30th, 2029 for the purpose described in subsection B. B, use of funds. Amounts made available under subsection A may only be used for 1, additional U.S. Secret Service resources, including personnel, training facilities, programming, and technology, and 2, performance, retention, and signing bonuses for qualified United States Secret Service personnel in accordance with subsection C. C, performance, retention, and signing bonuses. 1, performance bonuses. The director, at the director's discretion, may provide performance bonuses to any Secret Service agent, officer, or analyst who demonstrates exemplary service. 2, retention bonuses. The director may provide retention bonuses to any Secret Service agent, officer, or analyst who commits to 2 years of additional service within the Secret Service. 3, signing bonuses. The director may provide a signing bonus to any Secret Service agent, officer, or analyst who, A, is hired on or after the date of the enactment of this act, and B, commits to 5 years of service within the United States Secret Service. 4, service agreement. In providing retention or signing bonus under the subsection, the director shall provide each qualifying individual with a written service agreement that includes A, the commencement and termination dates of the required service period or provisions for the determination of such date, B, the amount of the bonus, and C, any other term or condition under which the bonus is payable subject to the requirements under the subsection, including 1, the conditions under which the agreement may be terminated before the agreed upon service period has been completed, and 2, the effect of the termination described in clause 1. Subtitle B, judiciary matters. I'm going to do that.
Section 100101, appropriation to the Administrative Office of the United States Courts. In addition to amounts otherwise available, there is appropriated to the Director of the Administrative Office of the United States Courts out of the amounts in the Treasury not otherwise appropriated $1,250,000 for each fiscal years 2025 through 2028 for the purpose of continuing analyses and reporting pursuant to Section 604A2 of Title 28 United States Code to examine the state of the dockets of the courts and to prepare and transmit statistical data and reports as to the business of the courts, including an assessment of the number, frequency, and related metrics of judicial orders issuing non-party relief against the federal government and their aggregate cost impact on the taxpayers of the United States, as determined by each court when imposing securities for the issuance of preliminary injunctions or temporary restraining orders against the federal government pursuant to Rule 65C of the Federal Rules of Civil Procedure. Section 100102, appropriation to the Federal Judicial Center. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of the Federal Judicial Center out of amounts in the Treasury not otherwise appropriated $1 million for each of fiscal years 2025 through 2028 for the purpose described in subsection B. B, use of funds. The Federal Judicial Center shall use the amounts appropriated under subsection A for the continued implementation of programs pursuant to Section 620B3 of Title 28 United States Code to stimulate, create, develop, and conduct programs of continuing education and training for personnel of the judicial branch, including training on the absence of constitutional and statutory authority, supporting legal claims that seek non-party relief against the federal government, and strategic approaches for mitigating the aggregate cost impact of such legal claims on the taxpayers of the United States. Subtitle C, radiation exposure compensation matters. Section 100201, extension of a fund. Section 3D of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended. 1, by striking the first sentence and inserting the fund shall terminate on December 31, 2028, and 2, by striking the end of that 2-year period and inserting such date. Section 100202, claims relating to atmospheric testing. A, leukemia claims relating to Trinity test in New Mexico and test in the Nevada site. Section 4A1A of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1 in Clause 1A and Subclause 1 by striking October 31, 1958 and inserting November 6, 1962. B in Subclause 2, 1 by striking in the affected area and inserting in an affected area, and 2 by striking or after the semicolon. C by redesignating Subclause 3 as Subclause 4, and D by inserting after Subclause 2 the following.
I've had about 15 root canals. I thought, is there anything I can do? At that point, I looked a little further And as I looked, I came across Nuvia. The thing that struck me was teeth in 24 hours. When I got my implants, it was different. I went right in, they put my new teeth in, and oh my gosh, the first look of these teeth. Oh.